So the Supreme Court en banc, during its special session today, on September 9, 2024, acted on the following matters. In the case of Aquilino Pimentel III et al. Versus House of Representatives et al., petitioners challenged Section 1D of 43 of the General Appropriations Act 2024 and Department of Finance Circular 003-2023, which allows the return of excess reserve funds of government-owned and controlled corporations, or GOCCs, to the National Treasury to fund unprogrammed appropriations. They also seek a temporary restraining order and/or writ of preliminary injunction to prevent the transfer of funds from PhilHealth to the National Treasury and preserve or restore the status of petitioners prior to the transfer of 20 billion pesos from PhilHealth to the National Treasury last May 2024. Respondents' House of Representatives and PhilHealth have filed their respective comments dated September 2, 2024. The case was consolidated with GR number 275405, entitled Bayan Muna Chairman Nery Colmenares et al. Versus President Ferdinand Romualdez Marcos et al. In this case, Bayan Muna representatives seek to nullify the Presidential Certification of Urgency for House Bill number 8980, or the General Appropriations Bill, absent the existence of any calamity or emergency under Article 6, Section 26, Paragraph 2 of the Constitution. They pray that the following be declared void: the presidential certification, the amount of 449.5 billion pesos inserted in the unprogrammed appropriations under the 2024 General Appropriations Act, and Section 1D of 43 of the unprogrammed appropriations in the 2024 GAA. The court required respondents in this case to comment on the petition within a non-extendable period of 10 days from receipt of notice, and required the personal service and filing of the resolution and comment. The court consolidated the two cases and set the oral arguments for these cases on January 14, 2025 at 2 p.m. Preliminary conference will be scheduled before then. Next, in the case of Rogelio Baterna versus Honorable Congressman Robert Ace Barbers et al. Rogelio Baterna filed a petition for certiorari with urgent prayer for the issuance of a writ of habeas corpus on behalf of his daughter Ronalyn, who is detained at the House of Representatives Custodial Center after being cited in contempt by the House of Representatives Committee on Public Order and Safety, or the Quad Committee, during its August 7, 2024 hearing on the alleged activities linked to the Philippine Offshore Gaming Operators, or POGOs. The court required the respondents to file their comment to the petition and prayer for habeas corpus within a non-extendable period of 10 days from notice. The court also required the respondents to file a return under preliminary citation within 72 hours from notice to explain Ronalyn's detention and why the writ of habeas corpus should not issue, without necessarily requiring respondents to bring her to court. Next, in the case of Reverend Father Hendrix Alar et al. Versus Republic of the Philippines. Petitioners filed a petition for declaratory relief and prohibition with application for TRO and/or writ of preliminary injunction seeking to declare unconstitutional Republic Act number 12000, which creates the Negros Island Region, composed of the provinces of Negros Occidental, including Bacolod City, Negros Oriental, and Siquijor. The court required the respondents to file their comment on the petition and prayer for TRO within a non-extendable period of 10 days from notice. And finally, in the case of Province of Sulu versus Executive Secretary et al., Philconsa versus Senate et al., and Dimaporo versus Comelec. The Supreme Court has unanimously upheld the validity of Republic Act number 11054, or the Organic Law for the Bangsamoro Autonomous Region in Muslim Mindanao, also called the Bangsamoro Organic Law, but declared the province of Sulu as not part of the Bangsamoro Autonomous Region in Muslim Mindanao, or BARM, after the province rejected the law's ratification. The decision is immediately executory. In this decision, The Bangsamoro Organic Law was enacted on July 27, 2018, and provided for the establishment of the BARM as a political entity and its corresponding basic governmental structure. The BARM's creation and determination of its territorial jurisdiction shall take effect upon the law's ratification by majority of the votes cast in a plebiscite. Majority of the ARM, or the Autonomous Region of Muslim Mindanao, ratified the law except for the province of Sulu. Despite this, Sulu was included in the BARM, prompting the province to file the present petition to assail the law. The court ruled that the Bangsamoro Organic Law is constitutional because it does not make BARM a separate state from the Philippines. The law did not give it the power to enter into relations with other states, nor did it grant the BARM its own sovereignty. Matters of national defense and security, citizenship, foreign policy, and foreign trade remain with the national government. The BARM's autonomy is limited to its internal governance. The fact that it was granted greater autonomy compared to other territorial and political subdivisions does not imply separation from the national government. The court also upheld the parliamentary form of the Bangsamoro government. An autonomous region is not prohibited from prescribing a form of government that is different from the national government so long as it upholds democratic principles. The Bangsamoro government is democratic, with members of the parliament elected by the people as representatives. In turn, the Bangsamoro Parliament elects a chief minister who shall exercise the executive powers of the Bangsamoro government. The court, however, declared unconstitutional the interpretation of the provision in the law directing the provinces and cities of ARM to vote as one geographical unit as to include provinces that rejected the law. This violates Article 10, Section 18 of the Constitution, which states that only provinces, cities, and geographic areas voting favorably in the plebiscite shall be included in the autonomous region. As Sulu rejected the Bangsamoro Organic Law in the plebiscite, it was wrong to include the province in the BARM. A copy of the available pleadings may be downloaded from the public pleadings section of the Supreme Court website. And the decision in this case of Province of Sulu versus Executive Secretary will be uploaded once the Public Information Office receives a copy of the decision. Thank you.